Viewers, welcome to Kanooni Charcha. Today I will delve upon a recent judgment of Supreme Court of India having title The Mother and Another versus State of Uttar Pradesh. It, it was a criminal appeal filed by the appellant, the mother and others with him. One with him, another with him. The trial court earlier acquitted him for the offences for which he was charged by the trial court. The offences involved was Dowry Death, punishable under section 304B, and cruelty to women by her husband and relatives, punishable under section 498A of Indian Penal Code. Thereafter, appeal was filed by the state, acquittal appeal. It was dismissed and the judgment of the trial court was upheld. Thereafter, obviously, state went to criminal appeal before the Hon'ble Supreme Court of India. The case was remanded back for a fresh decision of the Hon'ble High Court. Accordingly, thereafter, the Hon'ble High Court decided the appeal as per the direction of the Hon'ble Supreme Court of India, which was remanded to it. In this appeal, which was remanded, it was earlier an acquittal appeal against the order of the trial court. Again, the matter was heard in the acquittal appeal as per the direction of the Supreme Court of India. This time, the court convicted the accused. The Hon'ble High Court of Allahabad convicted the accused for commission of offence punishable under section 304B of Indian Penal Code and 498A of Indian Penal Code. In the year 1994, she suffered 100% worn injuries. Earlier, the case was treated as if it is accidental, but after some exercise, some investigation of getting suspicious that it is not an accidental death, it involves commission of offence under section 304B. Investigation was conducted and it was resulted into filing of a charge sheet before that. After the trial held before the Sessions Court, ultimately the accused was acquitted by the against this order of acquittal. The state went to in appeal, acquittal appeal. However, the order of acquittal remained upheld. Thereafter, the state again went to Supreme Court of India. In a criminal appeal, the matter was remanded back for fresh decision in the appeal. What was now thereafter, this time the Hon'ble Supreme Court of India convicted the accused for these two offences I have referred here. What is, I think, the para 7 of this judgment is very important. I will read out for the convenience of our viewers here. We have carefully gone through the records, and indisputable position is that death of the deceased. I will not refer here the name, no doubt name is there, had occurred within 7 years from the date of marriage. The marriage matrimonial ceremonies were performed 1992 and occurrences of year 1994. Within 7 years, it is admitted to, and this occurrence born injury she had received in the home, matrimonial home at Azamgarh, in her matrimonial home at Azamgarh. The evidence of the PW1 to PW4 would reveal that she was harassed and subjected to cruelty. This inference was drawn from the evidence which was on record by the Hon'ble Supreme Court of India. This is I'm referring on reading the relevant para. Though PW 1 to 4 were cross-examined on behalf of the appellants, nothing could be elicited to make them unworthy witnesses. The Supreme Court of India has gone that they were truthful witnesses. The cross-examination has not broken them as to their truthfulness. Though PW 1 to 4 were cross-examined on the behalf of the appellant, nothing could be elicited to make them untrustworthy witnesses. To that, as incriminating circumstances brought out by the prosecution were put to the appellants during their cross-examination under section 313 of Code of Criminal Procedure. In this case, a particular question was raised. The question was raised and put to the accused. Why he has cremated the dead body when it was already 100% burnt? Why there was this cremation? So now the Supreme Court of India has drawn an inference. That's something they have removed as which otherwise would be an evidence if the cremation was not done of the dead body. This is also an inference drawn. Furthermore, you might be known viewers, the occurrence of death of a woman at her matrimonial home within 7 years, a presumption is drawn under section 113B of Indian Evidence Act that it is a dowry death. The reversal burden is upon the accused. Reverse burden is upon the accused to rebut that it was this presumption is he is at liberty to rebut this presumption. But in the present case, he remained unsuccessful to rebut this rebuttal. Moreover, one more factor involved in this is that the theory of loss. The facts which are known to a particular man, he can explain about that. Section 106 of Indian Penal, this Indian Evidence Act, not Indian Code, but Indian Evidence Act as was applicable in the present case. What happened? It was found, it has surfaced in the evidence that accused and deceased was sleeping in the same. Then it is duty of the accused to explain as per the provisions of 106 of Indian Evidence Act how the deceased suffers burn injury. he is supposed to explain, because he and the deceased were sleeping in the room where she was found burnt. 100% here in the present case is 100%. This is a 100% one case. Then, but however, the Honorable Supreme Court of India has noticed that accused did not talk of sexuality. He has not led any evidence, much less otherwise made any explanation how in his presence the burn injury has been suffered by the deceased and how he did not, when he was also in the room where the occurrence took place, and she has suffered the 100% burn injuries. It is expected from a husband. Otherwise, not from a husband, anybody else also who sees that a woman is burning, to save him, to protect him, to make all efforts to. But in the present case, nothing comes out from the accused side how he has not intervened. Why he allowed this suffering, which the wife has suffered, deceased has suffered, in his presence. This is 106, the Indian Evidence Act, which talks that the facts, if or in knowledge of the somebody, is supposed to divulge about those. He is supposed to explain. He is supposed to. Now, however, in the present case, the accused remained unsuccessful. 2. Accordingly, this is also now the crux of this judgment you can find in para 10 of it's para 10. In view of the aforesaid circumstances, the evidence brought in by the prosecution and consequential failure on the part of the appellant to discharge their burden in terms of provisions under section 113B of Indian Evidence Act. Now I will stop here. I give a pause here. No doubt, presumption is against the accused that it is a dowry death. But this presumption is also rebuttable. Accused would have led some evidence and proved that it is not a dowry death. She has not been harassed. She has no demand was raised about the dowry. What are what are the ingredients of this? No doubt, the basic burden is to be discharged by the prosecution. Here in this case, it has been found that prosecution has remained successful in proving the burden upon them that it is a dowry death, because it has cost within 7 years of the marriage, and it is admitted that it is a death. Now the burden shifts upon the accused to disprove the so admitted facts. But in the present case, the accused could not. Under 113, presumption is accordingly drawn against the accused. Similarly, in about I will read furthermore, and the addition versus burden cost on the first appellant husband in view of section 106, what I have referred verbally earlier, where of the considered view that the High Court has arrived at the right full conclusion. जो second time the judgment came from the Hon'ble High Court of Allahabad, in that event there was a conviction of the accused for both the offences, view that the High Court has arrived at the rightful conclusion based on the evidence on record. They have appreciated the evidence, Honorable Supreme Court of India, which has earlier been considered and appreciated by the Hon'ble High Court of Allahabad, UP, and recorded their satisfaction that accused is liable for both the offences, or they have considered the evidence of individual 1 and 4, which they have appreciated as trustworthy evidence, which the same is the version of the Supreme Court of India in this judgment. We do not find any perversity in the appreciation of evidence. Meaning they have agreed with the appreciation made by the High Court of Allahabad in the appeal, while hearing the appeal against the order of acquittal. We do not find any perversity in the appreciation evidence. Consequently, in reversing the judgment of acquittal passed by the trial court and in convicting and sentencing the appellant as mentioned above, 2. They have agreed with the finding, appreciation, whatsoever considered about the evidence or other factors involved in this case. To put it shortly, no case is made out warranting any interference in exercise the appellate power of this court. Consequent appeals stand dismissed, conviction and sentenced were upheld. Now the question before us here is that the graph of dowry death is very high, and unfortunately the conviction rate is very low. You may check the data. Many dowry deaths are not reported. Firstly, if reported, those no doubt those were dowry deaths, but they are investigated as suspicious. Inquest proceedings are undertaken, and police and the magistrates who undertake the inquest proceeding, they close the case. Thereafter, if some case is proved, FIR is lost for dowry death and it is tried, the witnesses do not stand before the court. And now this judgment, I think, has created a confidence, faith among this justice seekers that Honorable Supreme Court of India and our high courts, various high courts of India and our trial courts take due care of how the justice is to be delivered. No doubt, if sometimes the matter of appreciation, if the trial court sum is being saved or otherwise gets saved from the trial court, then appellate court is there, the Hon'ble High Court in session trial cases. In special cases, if somebody did not get this justice, if justice is not done in some high court, then one can knock the door of the Honorable Supreme Court in the present court. This has been done earlier. Matter was remanded back to the Honorable High Court for having fresh decision, because earlier the Honorable High Court agreed with the trial court finding of acquitting the accused. The second time matter was again appreciated, and Honorable High Court found that is sufficient evidence, trustworthy evidence for convicting the accused. Accordingly, High Court convicted, and Honorable Supreme Court of India found the conviction and sentence made by this Hon'ble High Court. In accordance with law, no interference is warranted. Accordingly, they confirmed this conviction and sentence in this criminal appeal. I think this is sufficient for today. I have come across with this judgment and found that it is very important. It will certainly create a confidence, and people will not say that accused always go unpunished, and this crime unnoticed. It is not. So I have seen this case. This judgment is authored by C.T. Ravi Kumar, and with Honorable Justice C.T. Ravi Kumar was Justice Sanjay Karol. It is dated for 24th of July 2024. I think it is sufficient for today's episode. So please, I will again join you with a new episode. Thank you. Thank you very much.